Recording.
Good morning, everybody. Good morning, everybody. Today I am going to present about the Consumer Protection Act and its implications for the medical profession. It is going to be a small presentation. As you can see, there is just one slide that I am going to talk about. Not much to say about this. Before I start my presentation, I would like to ask a question, especially from the residents who are just settling in. Suppose there is a case against you of negligence. What all courts are there to which the patient or the consumer can take you? Resident sitting at the back. Anyone can answer that? Nobody? Okay, then I will tell the answer. As you can see in the flowchart, whenever there is a case of negligence, there are three separate cases that the doctor has to fight. One is a criminal case, the other is a consumer case, and the third is the case that he has to fight in the medical profession. And all three of them run simultaneously. It is not that you have to fight any one or two of the cases, all three of them run simultaneously. And the best example is the PB Desai case which I had presented in my earlier CGR, where that particular doctor, he was given punishment under all three of them. We'll discuss them one by one. So, whenever there is a case of negligence, there can be first a criminal case. Now, criminal case is there or isn't there, that depends on how gross the negligence is. If the negligence is very gross, it is involving or violating some law of the land, then definitely there will be a criminal case. And in a criminal case, there is punishment in the form of fine or imprisonment that can be given to the doctor. And all of us in government service are aware what is the implication of being convicted in a criminal case. The second could be civil case or CPA, that is Consumer Protection Act. Now, always remember, wherever you are working, whether that institute falls under Consumer Protection Act or not, the patient can always take you to court for compensation, if not in CPA, then in a civil case. So, just because you are not involved or you are not included under Consumer Protection Act does not mean that you cannot be asked for compensation. And personally, if I were there, I would prefer a case against me in a Consumer Protection Act as compared to a civil case, because in Consumer Protection Act there is a time limit within which the case has to end. However, there is no such limit in a civil case. So in a consumer case, I know the case will be over within say about 1 year. But if it goes to civil case, I don't know when it is going to end and how many years it is going to take. That is the second case. And the third is the medical council also. The respective medical council, whether it is state medical council or MCI, depending on where you are registered, the medical council can also take action against you. And that is in the form of warning notice or penal erasure. And this penal erasure, that is striking off the name from the medical register. It can be of duration from few days to permanent deletion, depending on how gross the negligence is. Now, what I was talking about, Dr. PB Desai's case, he was given punishment. He was given punishment in all of these. In criminal case, which we had discussed that day, in that the court had said that because the negligence was not gross, so the criminal case was not held there against him. However, even then, the court had given him punishment or imprisonment till the rising of the court, if you remember that. Then, in the civil case that was pre-Consumer Protection Act era case. So in that particular case, he had to award compensation somewhere around rupees 1 lakh to the patient. And in the third case, medical counsel, where he had accepted his guilt and he had accepted his negligence, he was given a warning notice. So that is the best example that I can give, where all the three cases run simultaneously. Now coming on to today's topic, which is the Consumer Protection Act. All of you are aware, this was the act that was passed in the year 1986, and it was passed to safeguard the interests of the consumers so that their interests are preserved. And till the year 1995, medical profession was practically not included in this. Various judgments based on how the case was fought in the court would in some cases say that yes, the medical profession is included, and in some cases the court would say the medical profession is not included. So till 1995 things were not clear, and it was only in the year 1995 the judgment came from the Supreme Court which categorically said that yes, medical profession is a part of, or medical services are a part of consumers, and the consumers can take medical professional to the consumer court. Now, this is the judgment 1995. So these are the four important judgments that we are going to discuss today. The importance of these is that they are landmark judgments which have defined how medical professional and consumer court are going to interact with each other. So as a medical professional, as a doctor, I would request all of you to be aware of at least the basic essence of all of these judgments. So today we are going to discuss them one by one. The first is IMA versus Nutri Shanta, which was given, as I said, in the year 1995. In this particular case, the court has dealt about four different situations. And now, let's talk about them one by one. The first situation is when a non-government hospital or nursing home, that means a private nursing home, is providing all services on paid basis. Now, in these cases, the court said it is very, very clear, when you are taking money from the patient, that means the patient is a consumer and you have to, or you can be taken to the consumer court for compensation. The second situation is when the non-government hospital or nursing home provides all services on free basis. This is basically applicable on all those charitable hospitals that are there. Now, in this particular case, the court has said that no, because money is not being paid by the patient, so the patient is not a consumer, and any negligence in these hospitals, the patient cannot go to a consumer court. Again, he can go to a civil court, but not to a consumer court. And important thing that the court said in this particular situation is charging of token money in the form of registration, say 10 rupees, 20 rupees, something like that, does not alter the situation. So even if the institute or the hospital is charging this token amount for registration, still that particular institute is not included in Consumer Protection Act. These two are very, very clear. The problem is this. When the non-government hospital or nursing home provides some services on paid and some on free basis. Now these some services can be in two different ways. One is where some services are paid and others are free, or it could be some patients are given totally free treatment and some patients are charged for the treatment. However, in both the situations, the court has made it very clear that these particular institutes will be covered under Consumer Act. The court has said that there cannot be two different types of treatment being given to patients, one who is paying and the other who is not paying. There has to be uniformity of treatment that is being given in a particular institute. So even if one particular service is being charged, then the whole institute is falling under the Consumer Act, and any patient, whether the patient has paid for his treatment in that particular hospital or not, he can take the hospital to the consumer court for compensation. So that is the partly. And the fourth is the situation regarding government institutes. Now the court has again very, very clearly said there is no distinction between a government and a private institute. All the three situations that we talked about regarding private institutes, the same apply to government institutes. So If the government institute is totally free, then it is outside the Consumer Protection Act. And if it is charging, for example, even us, we are charging for some services, we are very, very clearly under the Consumer Protection Act, and the patient can take us to the Consumer Court if there is any negligence on our part. So that is what this particular case did, and that was in the year 1995 when all these guidelines were finally crystallized by the Supreme Court. Now the next major thing that happened was in the year 2005 when this particular case came. Now, in this case, the court laid down procedures how in consumer cases or how in cases of negligence the police is going to treat the doctors. Before that, the first thing that the court talked about was what is negligence. This all of you are already aware. I am not going to talk in detail. I'll just go through it fast. The court has said that there are three components: duty, breach, and the resulting damage. All of these again you have all read in your classes. Duty is which is owed by the defendant, that is the doctor to the patient. Then there has to be a breach of that duty by not following the given standards. And finally, there has to be a causal relationship between this breach of duty and the damage that has been suffered by the patient. The important thing that was given in this particular judgment was the guidelines to the law enforcers regarding behavior with respect to medical professionals. The court had very, very categorically asked the government to make laws regarding this, and till such laws have been made by the government, these guidelines are binding to all. This is what the court's language was in this particular case. However, till now, except the Clinical Establishment Act, I have not read about any law that has been passed by the government, and we are talking about already 10 years. This was 2005. These are big slides. I'll first read and then explain them. A private complaint may not be entertained unless the complainant has produced prima facie evidence before the court in the form of a credible opinion given by another competent doctor to support the charge of rashness or negligence on the part of the accused doctor. What it clearly says is that if a person, private complaint means a person is lodging a complaint of medical negligence against a doctor, then he first has to produce a credible opinion by another competent doctor to support his charges. Only then can the court, this is for the court, only can the court initiate further proceedings against that particular doctor. So the onus of proving lies on the person who is making the complaint. Unless and until he can give an evidence from another doctor, that is also important. Till the time he gives an evidence from another doctor that yes, there is a case of negligence that is possible in this particular case, the court is not going to entertain that particular application. That is the first thing. This was for the courts. The next is for the investigating officers. Again the same thing. The investigating officer, before proceeding against doctor accused of rash or negligent act, obtain an independent and competent medical opinion. The same thing which the court has said for the courts, the same thing the court is saying for the investigating officer also. First, he should take an opinion, preferably from a doctor in government services, qualified in that particular field itself, in that branch of medical practice, who can be expected to give an impartial and unbiased opinion. Again, the investigating officer cannot just go to the doctor's home and pick him up, कि भैया तुमने तो negligence कर ली, मैं तुम्हें ले जा रहा हूँ. That cannot be done. He first has to have a opinion from another competent doctor from the same specialty, and if that doctor says yes, in this particular case it appears that there is a negligence, only then can investigating officer further go ahead and investigate that particular case or investigate that particular doctor. The next thing is regarding arrest, which we commonly see in TVs also and news also. The police would come and then arrest, and many of you, your friends, would have faced such situations. A doctor accused of rashness or negligence may not be arrested in a routine manner. I will not be discussing what routine manner is, because then that would be too much of a legal thing. However, the next slide will tell what it actually means. unless his arrest is necessary for furthering the investigation or for collecting evidence, or unless the investigating officer feels satisfied that the doctor proceeded against would not make himself available to face the prosecution unless arrested, the arrest may be withheld. What it clearly says is that unless and until the investigating officer feels that this doctor is not going to help or support in further investigation, or he is going to cause some damage to the further investigation, he is not supposed to arrest the doctor. So these are the guidelines that the court gave to the law enforcing agencies, how they have to proceed whenever there is a case of medical negligence against a doctor. That is not all. If this is for the law enforcers, the court also gave recommendations for the doctors, how they have to behave. The first is current practices, infrastructure, paramedical and other staff, etc. These should be observed strictly. These are the court's word. I have not added anything here from my side. Just plain simple copy paste from the judgment. No prescription should ordinarily be given without actual examination. The tendency to give prescription over the telephone, except in an acute emergency, should be avoided. Now, here the court is saying it should be avoided. Personally, I would say it should never be done, because I have myself investigated a case where a young 19-year-old girl died. She was operated for acute appendicitis, and then because the doctor had given prescription, the surgeon on telephone, and the nurse who took the instruction mistook it for something else, and that particular girl died. I was asked to investigate that particular case because I was the only forensic faculty there in that institute. So it is my personal request to all of you, please never ever give instructions on telephone unless there is an acute emergency and you cannot reach the place in time. A doctor should not merely go by the version of the patient regarding his symptoms, but should also make his own analysis, include tests and investigations. The important thing is where necessary. The court is not saying that just blanket every case should be investigated by every investigation that is available. Wherever it is necessary, you have to do the necessary test, but only when necessary, not otherwise. A doctor should not experiment unless necessary, and even then he should ordinarily get a written consent from the patient. So you have to follow the given protocols. You just cannot do whatever you feel like doing with the patient. Whatever protocols are there which have been devised by your specialty, people of your specialty, you have to follow them unless it is essential to go against them, and even then a proper informed consent from the patient is necessary. An expert should be consulted in case of any doubt. That's self-explanatory. And finally, full record of the diagnosis, treatment, etc. should be maintained. So these are the recommendations that were given by the Supreme Court in this particular case with respect to how the law enforcing agencies have to behave and also how the doctors have to behave. Now, the next case that was in the year 1999, which is this Martin D'Souza versus Muhammad Ishfaq. Now, in this particular case, the court made certain observations, and these are very important for us to know how the judiciary thinks. The first line itself is important. Judges are not expert in medical science, rather they are laymen. Right? So the court is accepting that they are not experts, they are not doctors, they do not know anything about medical profession. So whatever they are saying, whatever judgment they give, it is based on the evidence that we give in the court with respect to the person who has made some negligence or whatever the case is. Right? So that is the first thing that the court said, and this is very important. It is more going in favor of doctors. A balance has to be struck. While the doctors who cause death or agony due to medical negligence should be penalized, it must be remembered that all professional doctors who can make errors of judgment, but if they are punished for this, no doctor can practice his vocation with equanimity. Basically, what the court wants to say is that every case where the treatment has gone wrong is not negligence. Every case where the patient has not got the desired effect or desired benefit is not negligence. Negligence is when the doctor is not working or he has not followed the standard procedures or protocols or whatever are there. So the code is very clearly saying that we cannot have a sword hanging on the doctor's head at all time. Whether the patient should get this benefit, otherwise it is negligence. The court said no, that is not the case. And finally, the standard of care has to be judged in the light of knowledge available at the time of the incident and not at the date of the trial. As we are all aware, trials run in India for years, maybe 5, 7, 10 years, even more. So whatever happened, it has to be judged at the knowledge, the investigation, the machinery, whatever was available at the time of incident, not at the time of trial in the court. Suppose the case was, the case of negligence was there, say around 10 years back. Now, from 10 years till today, things have changed a lot. So the court is going to judge whether negligence was there or not based on what were the facilities available 10 years back, not based on what are the facilities that are available today. So these are the things that were given or observed by the Supreme Court in this particular case. So coming on to the last one for today, V. Krishna Rao versus Nikhil Super Speciality Hospital. This case has made things very, very different. I'll just show now. The recommendation given in Jacob Martin case, that was the one of 2005, where the court had given recommendation to the law enforcers as well as doctors. It says that they are only for criminal cases and the same cannot be used in consumer forum. Which means that if there is a complaint against the doctor in a consumer forum, then either the patient or the investigating officer, they do not have to take evidence or opinion from another doctor, which the court has clearly said also. In cases brought to consumer forum, expert evidence is not necessarily required. In fact, the court has said that in a consumer forum, in the Consumer Protection Act, that was made to speed up the processing, because there is a timeline also within which the case has to end. Now, if the case has to be investigated or it is a complicated case which requires a lot of opinion and a lot of evidence from other people, then the very purpose of a consumer court or consumer forum is defeated. Therefore, the court has said that in cases that are complicated, they have to go to civil court. And it is only simple cases, those like falling under res ipsa loquitur. Those are the kind of cases that should be brought to consumer forum. And those are the things where the consumer court comes into picture. Otherwise, it is better you go to the civil court and fight it out there. Like if expert evidence is required, then the person may go to the civil court. So, what we have discussed today is that starting from 95, when the medical profession was included in the consumer forum, till now things have changed quite dramatically. Earlier it was whether we are included there, whether we are not included, because Consumer Protection Act, it was silent on that, whether medical profession is there or not. However, in the latest amendment to the act that has come in the year 2002, whatever we talked about in the 95 judgment, that has been included. So now if you go and read Consumer Protection Act today, it is very, very clear that medical services are a part of services as under Consumer Protection Act section so and so. So that was not there in 86, but it is present there today in the 2002 amendment that came in that particular act. So we are included even in a government sector, even in AIIMS, we are included in Consumer Act. So any problem or any negligence that we do here, we can be taken to consumer court. Then the court has given guidelines how the enforcers have to proceed, and then finally in this particular case the court has said that those guidelines are only for criminal cases, and in consumer cases they cannot be followed. So that is all for today. Thank you.
What is the difference between the magnitude of punishment given by the consumer court and the civil court?
So consumer court will only give compensation, in the monetary compensation, and that monetary compensation depends on what is the expected or probable loss to the patient. For example, it can be a few rupees to, you have seen Kunal Shah case where it has gone into around 13 odd crore rupees. right? So that depends on what is the loss of the patient.
It's just a monetary compensation.
Yes. Consumer is only monetary compensation.
Is
Nothing
there
else.
a limit to which the consumer court can?
No. So different courts have their limitations. However, based on what is how much the compensation the person is asking, he will go to that particular case, whether in the state, whether national, or whether district forum. So national commission, it has no limit. It can give any amount of compensation.
So consumer courts also graded like.
So that would have been a state commission, national
So what is
state
the limit
commission.
for each?
Sorry, sir.
What is the limit for each?
So the limit is in the state commission it is 20 lakhs. In the district commission, then state commission up to 1 crore, and national commission beyond 1 crore. And after that, if the patient wants, then he can go to Supreme Court also, even against national commission.
So before you go to the consumer, do you have to go to the state medical council or something?
No. Medical counsel is, these are three totally different things. Criminal case is totally different, consumer is different, medical counsel is different.
Till how many years after that complaint can be filed?
Usually, actually it is said that it has to be within 2 years. However, based on certain things, or based on if you have a good lawyer, the patient has a good lawyer, he can even convince the court that yes, the delay was justified, and even later the courts have accepted cases and even given compensation later. However, as per law, it is 2 years. 2 साल तक तो ध्यान रखना है.
Routinely, for how many years a hospital is supposed to keep the records?
Sir, for record maintenance, there are DGHS guidelines, and the DGHS guideline says that for inpatient it has to be for 10 years. For medical legal cases, it is either 10 years or till the case is running, whichever is later. And for OPD, it is 3 years. OPD records.
Whose responsibility is it to maintain the record?
That the institute has to decide. But you have to formulate a policy.
In the court of law, what is acceptable?
The court will send the summon to the concerned person. Okay, or usually if it is, suppose there is a case of running against a doctor, then the court will send the summon to the doctor and he will have to take the record. Or if the doctor is not required, then court will send summon to the head's institute, MS or whoever is the institute, and ask that to send the record clerk with the documents. So then in that particular, the record clerk has to go, and if there is no such record clerk or there is nobody who is, then the institute's head has to go.
Dr. Puneet, can a person approach all the three authorities at a time for compensation to the consumer court and to the MCI to delete his name from the medical register, and to the civil or criminal court for criminal negligence,
Yes.
or like that? One can do that?
Yes, one can do that, all three. Then, based on whether the negligence is gross or not, this criminal case, whether it will run or not, will be dependent on how much damage. Suppose there is just minor damage, then probably criminal case may not run. Right? The court may quash that appeal. Then consumer forum, then that will be going simultaneously, and in the medical counsel, even a lawyer is not required. When a patient is approaching a medical counsel, not required, in fact lawyers are not allowed to present the case also in medical counsel. The patient has to go there and present the case himself.
Before any procedure involving any risk to life or otherwise, consent is usually taken. So what is the importance of that? If that is missed, or if it is there, does it make the case stronger or weaker in any way?
So if you do not take consent, that means that you have done something which the patient did not want to do. Very, very clear. Right now,
So if the signature is not there, you are in suit.
yes.
Informed consent is okay, I mean verbal consent, because for
Ma'am,
FNAC we don't take any
legally there is no difference in a verbal or a written consent. These are the Supreme Court judgments that there is no difference between a verbal and written consent. However, if the case goes to court, you cannot prove a verbal consent. So for your personal safety, that yes, you actually took the consent, it is always better to take it in writing. Because how are you going to prove that the person had given consent if it is a verbal consent?
Form which says that there is an informed consent and with respect the procedure to the patient. Because the consent also says it has to be in the patient's own words, in the language that they understand.
Yes.
And if the patient has to sign a consent, it's better for any complicated procedure that they write it in their own words.
Yeah.
Otherwise, tomorrow somebody can always come and ask that I was in a state of mental distress. I do not know what they made me sign. So they have to sign whatever, in a complicated situation, they have to sign whatever they want, your consent, they have to sign in their own words.
And it is always better in such cases, if you feel that the patient is mentally not stable, always better to take signature of one of his relatives also, as an added safety.
And in a situation where you feel that the patient is otherwise not well or the signatures may vary, it's best to take a left thumb impression.
Yeah.
How many witness signature is necessary in such cases? 0, 1, 2,
One is usually sufficient.
So just in a simple case, like we are giving IM injection for pain and the patient developed gluteal abscess. So we are not taking any consent for the such procedure. So we are at the fault or what?
So in these cases, it is usually implied.
Implied
मतलब जबरदस्ती पकड़ के तो
Yes, that's, but after that he will
So
say
that is an implied
I have developed like gluteal abscess and if we go to some...
See, he cannot say that you did not take consent, but he can definitely say you did not do the procedure properly.
No, one more thing. The consent is for injection, but usually the informed consent means that we have to explain all the possible complications in a reasonable things. The gluteal abscess, though it's very remote, do we necessarily tell every patient that abscess might
If you start explaining every possible complication, then no patient is ever going to take it. So it has to be a reasonable balance.
Because a consent doesn't provide you immunity from this.
So consent just tells you
Consent
that
is
what
for purpose of research, it doesn't provide you immunity.
consent.
Patient has to prove your negligence even after you are
So many times patients have gone to court even when there is no negligence, saying that my consent was not taken and the doctor did this.
Second doctor's opinion is important.
So even there the court has said that yes, consent is important and you have to do only the thing for that the consent has taken.
Yes.
For example, I'll just tell an example, a case which I have gone through. A patient, she was a female patient, she went to the gynecologist and the gynecologist had taken consent for vaginal hysterectomy. And instead of vaginal hysterectomy, she did abdominal hysterectomy. Right?
Civil and criminal case can be any.
Sir, next.
You know what? At least government hospital has been given some protection. Reason being, money is not taken by a particular physician or surgeon. The case would be filed against the hospitals, not against the particular doctor.
Sir, the patient, he will file the case against that particular doctor. He knows that doctor who treated him. What happens there in the court?
Also the cases, I have also been also in charge in many cases, but doesn't understand.
Usually it does not happen in government hospitals,
Yes.
but that does not mean
that doesn't want to be given immunity.
Like, for example, land institutions, highly subsidized, what you are charging for your diagnostic. In that situation, does the same rules hold good when you are in a private hospital? There's somebody
So the court has said, if it is just a token amount that you are taking,
Whatever you are
a token registration amount if you are taking, then you are not included. Otherwise, whether it is subsidized or whether it is full rate, because subsidized or full rate, nobody can decide. What is the rate? So, because even for same thing, different hospitals can charge differently. That's why you cannot say because we are subsidized, so we should be given any preference. The court says that.
Puneet, I want to ask you a question. How does the law apply to alternative medicine? Ayush.
Sir, I don't know.
Same. Law is the same.
What somebody has taken consent for a particular surgical procedure, and during the procedure he needs the need for another procedure to be done. So what should be done in those cases?
If it is required as an emergency for life-saving thing, you take a consent from whoever is present with the patient and do. If it is not a life-saving procedure, then you are not allowed or supposed to do it. You take the patient to the OT a second time.
In a government institution, who pays the compensation, doctor or the institution?
That the court decides. There have been cases where the court has held state government vicariously responsible and asked state government also. The court has asked the doctors also. That depends on the particular case.
And what happens when some junior staff has done some mistake and patient?
Again, it will be on the case-to-case basis. What is the mistake and who is responsible, whose responsibility can be fixed? That is again depending on that particular case. That there cannot be a general guideline that this person will be.
Sir, as far as informed consent is concerned, like if a procedure is technical enough, even if we convert the things into Hindi and try to explain to the patients, but the type of crowd we are dealing here may not understand that also. So in that case, how to take an informed consent?
Ideally, it has to be in the local language. Marwadi mein पूछ.
There are certain
But for us, because then in that case we don't know that language, right? For example, if I have to take it, I don't know Marwadi. I will only explain in Hindi, and at the most I can ask one or two of our relatives or the patient's relatives who are there. This is what the thing is, and explain it to them in Hindi, and then take it in Hindi.
Now, one last question. It's not related to medical things, but as far as Consumer Protection Act is concerned, the other professions are also involved in it by default. But why is it so that there is so much sensitization when we are only about the medical profession? We rarely see any case against any other professional, maybe architect or lawyer or engineer or whatever. So, what's the basic means?
Many cases, but we are not.
What I can say is, as far as medical profession is concerned, all specialities are included in Consumer Protection Act, right from anatomy, because they are also doing embalming and all, and it is again charged. And most places embalming is done by anatomist only. So if something goes wrong, so right from anatomy to everybody is included except me, because my duty is towards the court and not to the patient.
So despite taking all consents and everything, if case is filed against some individual doctor, then in a government institute, does the institute protect?
Yes. That directors are getting.
See, in an institution, when you are working as a consultant and thing, if something goes wrong and the case is filed, normally the institute does also an internal exercise as what has gone wrong. That's one thing that you do. The second thing is if you're going to fight without, so that's the internal thing. The institute will definitely defend the person or have the thing about the level of negligence or whatever it is it really negligence at all or not? And normally the institutions do fight on that. In private, everybody has this indemnity insurance that they do, but in institutions, most of the places I don't see that they have this insurance because the institution takes care of whatever is the case, because the person is working in the institute and is whatever is carrying out within the institute. So the institute has this right and should defend the person who's working at your place. If a resident does something wrong, you're not going to put the resident forward. You're the consultant, whoever is the consultant is directly, the resident is supposed to be working under supervision. Even as the senior resident person that has the powers to do things, if you ask him to do things, but overall he's still with the consultant somewhere. So there is a supervision. If he's taking a decision, he has to inform the consultant that he's taking this decision or he's taking, but it cannot be that a free hand that you go and do something and then the consultant says, what have you done, and then he's in the suit.
So it's like in private institutes, they have their lawyers. Usually, I don't know what the policy is in the government institute, but it is always advisable. Like, for example, we have our MOU with NLU. So we can always approach them for fighting our cases because we are dealing with them. Like, because of our MOU with NLU, we can ask them and or whatever be the policy that is there.
Sponsor your realty.
But sir, I cannot like practice both. So it's only if the case is against me I can fight with the court. Sir, उतनी हो गई. Sir, उतनी तो हो गई जितनी जरूरत पड़ती है. I cannot go and defend. That is the thing. Because it is very, very clear that a person cannot practice both. You can either practice as a lawyer or as an advisor for the institution.
See, government institutions also at times say that this negligence that happened because they are bursting at the seams or overworked or too much crowd. How does the court look at it that way?
So that is again case to case basis. Depends on what, if you can convince the court, yes, it was not negligence, it was due to problems that have been created because of overburdening or overcrowding, then the court may accept it, court may not accept it.
See, there the expert witness's opinion is very important. Because if your expert witness comes and says that whatever the amount of burden that the doctor was under, it is up to him to decide what is safe for a patient. So if he's not practiced the basic safety issues, then he's liable to be questioned about what he has done. At the end of the day, the doctor or the treating physician is responsible for the procedure. So I don't think that is a blanket protection for anything in a court.
No, that's what I'm saying. It is case to case basis. Whether you can convince the court that yes, whatever happened, it could not be prevented, then the court may accept it. And if you cannot convince the court, then the court will not accept it.
So, if a person is falsely trying to frame a doctor, that the doctor is at duty and finally it is found that no, the doctor is not at duty. So, is the case just crashed or does the patient and that person gets any punishment or no?
In law, if the case is, there is no proof, then that case is over. If you want to take any revenge, then you have to file a counter case against that person.
Regarding these 2-3 questions asked about the consent, is all will follow these 3 criteria. One is this information provided by the doctor, second is the competence on the patient party, and third is the voluntariness. Since the local language Marwari, we don't have Lipi. It will be maybe in Hindi and bracket we may write just because explain in local language just Marwari. Then patient was in position for competence, maybe the family member in some cases.
It's always better to write that this was, and it was done in the presence of this who understands this language, and it was explained to this particular person, and take his signature.
See, we have been trying to start our research activities. On 28th, we had a flow cytometry workshop. Unfortunately, I think only 20 of you attended. I think that's not the way we are going to be looking forward as far as research activities goes. That goes for the faculty and for the residents